This could have all been avoided with well-contemplated, intelligent discovery questions. As a divorce attorney who's done countless divorces, I can tell you that legal strategy and preparation can significantly impact the outcome of the case. One of the most crucial stages in divorce is discovery. That is the process of obtaining information from the other side and them obtaining it from you about everything from finances to potential witness lists. It could include depositions, subpoenas, and more. Now here's a lesson for this video. Do not skip discovery even in an amicable case. There are certain pieces of information you might pick up in discovery that could greatly affect the outcome of your case, including your financial settlement. I just heard about a recently completed amicable divorce after 14 years of marriage where the parties had shared access to accounts and were divorcing just because they lost their connection. That was it. There were no allegations of abuse or cheating, and they informally exchanged the latest financial records, and they completed their divorce based upon just their latest financial records. Then, less than 2 weeks after the divorce was completed, one of the spouses accepted the CFO position in a competitor company to the one where he had been working for the last 4 years of their marriage, and that position now pays him 3.5 times his former salary. Now here's what's really shocking. I learned that there was no formal discovery done in this case and no questions asked about whether that party was currently interviewing for any new positions or being considered for a promotion either at their own company or had accepted a promotion with a start date, or whether there are any career decisions that were being held off until the divorce was completed or anything like that. Now, it's very obvious to me that this person's job search and interview process were well underway during the time that the divorce was ongoing, and they either held off accepting or held off starting that new position at 3.5 times their prior salary until after the divorce was completed. If the other spouse had been aware during the divorce proceedings of this new position that their spouse was interviewing for, which more than tripled their income, they would have potentially been able to make the argument for greater alimony or a greater share of the marital assets, etc., under the premise that the spouse who has that new 3.5 times job offer will have a very easy time recovering from the financial effects of the divorce and continuing to save for the retirement, as well as several other arguments in support of them that I won't get into here. I'm just keeping it basic for this video. If the spouse with the new job had failed to disclose this pending new 3.5x salary in their discovery responses if they'd been asked, then the other spouse would have had a basis to seek a post-judgment, in other words, a post-divorce action, perhaps reopen the case or even set it aside, subpoena the information about the job interview process, offer letters, and other information proving that the spouse who took that new job had hidden information from them. But since none of these types of questions were asked in discovery because there was no real formal discovery done, remember, they just exchanged their latest financials, then there is no basis to allege that this spouse who got the new job failed to honestly disclose this information, and therefore there's no basis to seek a reopening of the case and a recalculation of the alimony and the division of the assets and retirement accounts, etc. Now remember, these two were not having a combative divorce, they were very amicable, but contrary to that old saying, what you don't know can definitely hurt you. Not knowing that their spouse was waiting for the divorce to be over before accepting and starting a new job at 3.5 times their old salary definitely has hurt the other spouse. This could have all been avoided with well-contemplated, intelligent discovery questions. Either the new job would have been disclosed, or upon learning of it later, the other spouse would have had a valid claim to request that the terms of the divorce be set aside, the case reopened, and they likely would have been able to request that the spouse who lied in discovery be required to pay for the aggrieved spouse's attorney fees. So, what's the lesson here? The lesson is do discovery in every divorce and ask intelligent questions. Hey, thanks for watching this video. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos and leave us some comments, ask us questions, tell us what other topics you'd like for me to talk about in these videos. Join our Facebook group at Georgia Divorce and Custody for even more information. And as always, I look forward to seeing you on the next video.